Great.
And if you want to take it away, friends, and get us
Thank you. Thank you so much. Thank you, JDI. Thank you, Greta, for inviting us and organizing this. I just want to make sure before I start talking that I can share my screen so I can get the slides up if that's possible. So as Greta said, we started thinking and talking about how to share as widely as possible information about the eviction ceiling law that just came into effect at the end of May. And we started talking about how to specifically share this information with folks who are working directly with survivors. And the idea for this series of trainings came together pretty quickly at the end of the summer. So you might be here because you're really excited about eviction ceiling, and we're excited that you're excited. And also, we decided to start this training series by doing a little bit of like basics about eviction law and how to advocate and support a survivor who is a client who is dealing with eviction. Um, Before we do part 2 of this training, which is going to happen in a couple of weeks, where we really dive into the nitty-gritty of how do you seal an eviction, how do you know if an eviction is sealable, and what are your step-by-step kind of action items around eviction sealing. So please bear with us. This is the basic kind of what you need to know about evictions and what are the specific protections available to survivors in the context of trying to prevent an eviction. But if that hasn't happened, or you meet someone after, right, after they've already experienced an eviction and you know that they have an eviction on their housing record, what do you do about that? And what are your options? So we hope you'll come to part 2. And we hope that part 2 will make more sense given this kind of shared background that we're building together today. So with that, I'm going to start sharing slides, and hopefully folks will be able to see the correct slides. And I hope someone will give me
It is starting to come on, I think.
okay, here we go.
They're just loading. Yeah, there they are.
Okay. And now I'm putting it on slideshow format. So I'm just checking that you can see the slideshow, the big slide, and not the like prep slide deck.
Looks great. Looks gorgeous.
Okay, thank goodness. All right, wonderful. So this is Eviction 101, what you need to know to support survivors who are dealing with an eviction. And I'm delighted again to be here with you all. And I'm so excited to introduce you to my colleague, Vineeth, who I will introduce or will let introduce himself in a moment. But just to give you a lay of the land for what we hope to accomplish in this very quick hour that we have together. We're going to do some basics on eviction, and then we're going to go into all the different types of housing protections that might be available to a survivor who's dealing with eviction, depending on what type of housing they live in. Okay, so we're going to kind of get pretty specific about what rights someone might have in each type of housing. All right. So as Greta said, I'm Julia Devanthéry. I teach the Housing Law Clinic at the Legal Services Center of Harvard Law School. We're located in Jamaica Plain. I've been doing housing law and representing tenants for quite a while. And in the course of that work, really became aware of how often gender-based violence causes housing instability for our clients. And so in 2017, I founded a program within the housing clinic at the law school called Housing Justice for Survivors. We do really focus on representing survivors who are dealing with a range of housing issues, but eviction is really at the core of that practice. So day in and day out, what we're trying to do is just make sure our clients who are survivors are able to stay in their homes, or if they can't stay in their homes, that they're able to relocate to safe housing as quickly as possible and without losing or jeopardizing their housing benefits along the way. And just recently, I was lucky enough to be joined in this work by Vineeth, who is here with us and is going to be sharing some of the training with me today. So Vineeth, do you want to introduce yourself?
Yeah, great. Thank you so much, Julia. And I'm so happy to be here with all of you today to do this training. So I actually previously was an attorney with the Legal Aid Services of Oklahoma out in Oklahoma City, representing victims of domestic violence. And then most recently, I was in Holyoke at the Massachusetts Fair Housing Center, representing victims of housing discrimination. And so when this opportunity came up to work on this kind of cross section of domestic violence and housing, this seemed like a perfect fit for me and something that I felt like I could bring my, experience in both areas and really, try to, help out folks that were, suffering from or, facing housing challenges, uh, based on their status as a survivor. And so I was excited to join Julia in March of this year, and and excited to talk to you all today and go through this training and answer some questions at the end.
Yay. Okay, excellent. So we're going to start with Eviction 101, which is really just the basics of what you need to know about evictions, not because you're going to be representing someone necessarily as a lawyer, but because there's a lot of procedure and there's a lot of law that can feel confusing and overwhelming. But if you start to recognize some of the signposts along the way, it becomes a little bit more clear about how to advocate for someone who is going through this experience. So this may feel like, for some folks in the room, like very much review, like super basic, and for others, you might be learning concepts for the first time. And our goal is at the end of this training that we're all kind of like sharing an understanding of what eviction looks like and what are tenants' basic rights in the process, and then more specifically, what survivors and their advocates can do to protect against eviction if at all possible. So if there's nothing else that you take away from this training today, let it be this, okay? In Massachusetts, no one can evict a tenant besides a judge or a jury, okay? A tenant cannot be forcibly removed from their home unless the landlord has gone through a court process and gotten permission from a court to go ahead and remove the tenant. And that applies to all types of tenancies. That applies whether there's a lease or no lease, whether the lease has expired, whether it's a tenancy at will. Nobody can be thrown out of their home before they're ready to leave without a court order. Okay, so that means that changing the locks, intimidation, bullying, all the kinds of behavior that you may have come across and your clients may have gone through, if the landlord is not going through the court process, what the landlord is doing is not lawful. That doesn't mean it doesn't happen all the time in Massachusetts, but what it means is we want to recognize when something is definitely outside of the law. And so when a tenant might be facing some unlawful actions by the landlord, in the nature of, for example, telling them they have to leave or telling them they're going to remove their stuff or change the locks, you can recommend that that person actually go to their local housing court and talk to the court about what options might be available. Also, connecting them with free legal services in their community is often a good next step. Sometimes, if somebody is facing an illegal lockout situation, the recommendation has been to call the police to try to get the landlord to let the tenant back in. Calling the police is not something that our clients always feel comfortable doing, and so it's not something I would just recommend very generally, but that is an option in terms of trying to make sure that a landlord allows a tenant back into their home and does actually go through the appropriate process before going forward with an eviction. So that being said, the golden rule is only a court can evict a tenant. Landlord can't do it without first getting permission from the court. And while a tenant is living in their home, they have a right to safe and sanitary housing, in the sense that every rented apartment in Massachusetts has to be maintained at a minimum standard for human habitation. And that minimum standard is set forth in something called the State Sanitary Code. The State Sanitary Code is kind of the health code, right? That tells landlords like what's the minimum condition that you have to maintain your apartment in order for it to be a lawful rental. So those kind of basic ideas aside, there are times when the landlord-tenant relationship breaks down and where a landlord might be starting the process of initiating an eviction. The very first thing that a landlord would have to do in order to start an eviction is to terminate the tenancy. And that legal document that terminates the tenancy is called a notice to quit. Sometimes we call it an NTQ for short. Usually we see two different types, two different flavors of notices to quit, the 14-day notice to quit and the 30-day notice to quit. The 14-day notice to quit, generally speaking, is correlated with non-payment of rent allegations. So the landlord is saying, you fell behind on your rent, I'm terminating your tenancy, I'm giving you 14 days notice. At the end of the 14 days, you need to pay or you need to leave. And if you don't do that, I'm going to start an eviction case. And then a 30-day notice to quit is pretty much for any other allegation of lease violation, or in certain situations for no reason at all. If you have a tenancy at will and the landlord is trying to raise the rent, tenant hasn't done anything wrong, but the landlord is seeking a higher rent from the tenant and the tenant's not prepared to pay, for example, that would be a no-fault notice to quit, and the tenant is entitled to at least 30 days. This document is very stressful to receive, okay? Even though it's the very first thing in the whole process, and if you understand that it's the very first thing and you know that there's a lot more time potentially in this process, you see it for what it is, which is the starting point. But if you don't know that that process is ahead of you and you get this piece of paper, it's very scary because it has very strong language in it. It says, you must move. If you don't move, I will use due process of law to eject you from your home. And unfortunately, it can be the document itself can be something that triggers a lot of anxiety and can even in some cases be trigger some trauma responses for our clients, understandably. So what we can do ideally is to try to de-escalate by explaining, look, this is the first thing that has to happen before the landlord can take you to court. You don't have to move out by the end of this document's time period. But the next thing that's going to happen if you don't move out is you're likely going to see your landlord filing an eviction case. And once that happens, you're going to have some other options to try to prevent the eviction from going forward. So that is the next thing that happens, okay? The next thing is that if the tenant hasn't moved or the landlord and the tenant haven't kind of come to terms about how they're going to resolve whatever the dispute is, then the landlord is going to start the eviction case. And in Massachusetts, the legislature has created this process for eviction that's actually called summary process. And the reason it's called summary process is because it is very fast compared to any other kind of sort of lawsuit that you might see on the civil side of things. It's going to happen in the blink of an eye if you don't know how to protect your rights and slow down that process. But the summons and complaint is a court document. It's a document that the court prepares that the landlord buys from the clerk's office, and then the landlord has to have served on the tenant by a constable. And that's how we know that the court case is getting ready to be started. The third step in an eviction in Massachusetts at the moment, and I say at the moment because this procedure is pretty new. It's kind of like a COVID and sort of post-COVID change in the procedure, where the court actually requires that that both sides, the landlord and the tenant, come to court to do a mediation. And the mediation happens at the court, and usually it's facilitated by a court employee. Although a lot of times what happens is that just the landlord and the tenant start talking to each other directly, and they don't necessarily have any third party, in that conversation with them. And that can be fine, but it often is the case that the tenant is unrepresented by a lawyer and that the landlord is represented by a lawyer. So you have this real imbalance of power. And you have a lawyer who's probably pretty experienced, has a lot of cases in housing court, knows the ropes. just kind of telling the tenant, this is the deal I'm willing to offer you, take it or leave it, right? And it's not very balanced. And if the tenant doesn't know their rights in that process, they can feel stressed and intimidated into agreeing to something that maybe isn't fair or isn't doable for them, right? They have a hope that they can comply with the terms of the agreement, but the terms of the agreement are not necessarily made with their needs in mind. And so there's a pressure to settle. So what I want to recommend, if you have a client or a participant who's going through this situation and maybe has an eviction mediation coming up, again, is to try, if we can, to connect that person with free legal assistance to fill out paperwork that will help them protect their rights in the process. You do in Massachusetts have a constitutional right to have your eviction case heard by a jury of your peers, as opposed to just a judge who may hear hundreds of cases a day and maybe might not stop to give you exactly the attention that you feel your case deserves. But the issue is that the tenant has to ask for the trial by jury by a deadline. And the deadline is 3 business days before that first mediation. So if you are working with someone who has gotten a notice of mediation and you're still more than 3 business days away from that date, you're actually in a magic moment where connecting with legal help to do this paperwork called the answer, the jury demand, and the request for discovery could really change their case. Okay. And I know better than most that free legal help is not available to everybody who needs it in the housing space. So if connecting with a lawyer and getting representation is not going to be possible, there's actually a free online resource that helps, just asks the tenant questions. And you fill in the answers to the questions and it makes these documents for you and helps you file it directly in court. That's called the MAID program. And it was developed by our colleagues and collaborators at Greater Boston Legal Services. So you have the URL here, you'll get these slides and you can use that. So it's sort of like, if you can get a referral to legal assistance and free legal help, that's the ideal. If you can't, helping the client or letting the participant know about the MAID option to get that paperwork filed is hugely important. I saw a hand a little while ago, and I think Vineeth mentioned we are really hoping to have time at the end to talk through questions. If it's okay with everyone, I think we would love to power through some of this material because there's quite a lot that we want to make sure you have, and then maybe save the questions and conversation for the end. If there's anything that feels like like something that requires clarification, maybe someone can, maybe you can chat your question, like something's not clear, can you say that again? Or I didn't understand that. Please put that in the chat and then hopefully someone can watch the chat and flag for me when there's clarifying questions that come up.
Yes, I'm happy to do that, Julia. I will do that. And if folks have accessibility concerns that are coming up, and I can fix that for you.
Awesome. Thank you so much. Okay, so we were at step 3, right? There was a mediation. There was an attempt to have a settlement conversation, but maybe the tenant didn't feel comfortable settling because the terms that the landlord was offering were just not fair to them. They didn't feel comfortable with them. So no settlement happened. Then therefore, the next step in the case is that the case is going to eventually be heard either by a judge or by a jury. And the most important thing is to show up for this for all court dates, but in particular the trial. Make sure that there's the tenant is showing up, that they're being noted as present, because if they're not noted as present when the case is called, it's an automatic loss. And then it becomes kind of harder to get your case heard if you don't show up on that day. Make sure to bring all the evidence that might be relevant to the case. So any documents, any witnesses, any receipts, photographs, anything that the tenant wants to present to the court needs to be with them that day, and not on their phone, right? Like sometimes we have amazing photos or videos, but if they're on the phone, the court is not able to see them or show them. So things have to be printed out or like on a drive that you could hand in. And those are really important to come prepared with to present to the judge or to the jury. The landlord's going to do the same thing. So both sides are going to get an opportunity to share what is important to them and what their legal claims are and their defenses. That's really where it happens. There's not a lot of magic, right, to these cases. Both sides show up and they say their side of the story, and then the judge or the jury will make a decision. But what I want you to take away, just like I said, like if you listen to nothing else and don't remember anything else I say, it's that only a court can evict a tenant in Massachusetts. The other really important piece of information is that in Massachusetts, a tenant can win an eviction, even if they have fallen behind on their rent, even if there has been some alleged violation of the lease. There are opportunities for the tenant to both play defense and also play some offense. So if the landlord hasn't done their job under the law or under the lease, or if the tenant has a defense under, for example, the Violence Against Women Act, which we're going to talk about in a moment, or if there's a disability and this is a reasonable accommodation situation where the tenant needs an accommodation from the landlord. All of those things could if the tenant presents them and the judge or the jury accepts them and finds that information credible, then the tenant could win at the end of the case. The tenant could stay in their home at the end of the case. And that is not the same in every state. So I want to make sure we understand in Massachusetts, tenants can win evictions, even if they fell behind on their rent. And so at the end of the day, you're going to want to wait to get the judge's decision. A lot of times the judge will not make a decision right away from inside the courtroom, from the bench. They'll go back to their office and write it up and send it out. If it is a case that's being heard by a jury, you will get the verdict, that day, and then you'll know what the result is. So if the tenant doesn't like the result, thinks it's wrong, then there's actually either side can appeal the decision, but that appeal has to be filed within 10 days, which is a very, very fast, quick window of time. And then if nobody appeals, the winner of the case can go to the court and say that they would like their execution. And the execution is the legal document that either side would need to sort of effectuate whatever the judge's decision is. So in the situation where the tenant has lost and has not appealed, the landlord gets the execution from the court. The soonest they could get it would be 11 days from the judgment. And then that is the piece of paper that would allow them to go forward with an eviction. Okay, that's the eviction paper that we really want to be alarmed about, not the notice to quit, which might be weeks and months ago, right? Although that is scary, we want to be clear that's the start. The execution is the end of this process. And once the landlord gets the execution, they still have some more process to do. They have to bring it to a constable, and then a constable has to serve it on the tenant, giving the tenant at least 48 hours notice that the forced eviction is going to take place on a specific day at a specific time. And that needs to be during business hours on a weekday. Can't be on the weekend or a holiday. And at that time, if the tenant is still in the property, the locks are going to be changed, the people are going to be removed, and the belongings are going to be boxed up and put into storage. And that's the eviction, right? And that is a terrifying rupture, right? In a family or an individual's life, if it does come to pass. And it's something we want to try to avoid if at all possible. But at this point, there's only a few things you can do in court to prevent it from happening, okay? And you would have to, the tenant, once they receive the 48-hour notice, they have to go straight to court with that 48-hour notice and file what's called a request for a stay to stop or delay the execution from going forward. And in plenty of instances, those can be successful, but it really is at that point up to the judge to decide. It's purely discretionary. So ideally, there has been an intervention of some kind earlier in the process where there could be more opportunities for the tenant to push back and say their side of the story. Okay, so we do everything we can to prevent that last moment. But if it does happen, I want to make sure you know what that process should look like. And that's it. That's the whole sort of overview of the eviction process that we want to make you aware of. And then now, I mean, this might be a little stressful and a little, might be a bit of a downer, right? That this process is out there, that it's fast, that it can, that we live in a society that allows this to happen at all, not much less, thousands of times a year. But here we are, and what can we do about it? Okay, so that's kind of the next part of our presentation. So we're going to talk about what are the protections that are currently on the books for people who have experienced gender-based violence to help them stay in their housing or to help them relocate if that's what needs to happen for their safety. And so at a federal level, we're going to be talking about the Violence Against Women Act, VAWA, which I'm sure folks on the call have some familiarity with. And then on the state side, there's some state laws and some state public housing regulations that we want you to be aware of. So now we're talking about, okay, what can we do about this, right? What are survivor rights to stay in their housing, regardless of whether this is a non-payment of rent situation, allegations related to a violation of the lease, for example. What can we do to help prevent evictions whenever we can? All right, so number one, folks, this may be obvious to many folks here, just depending on your work with the Violence Against Women Act, but I just want to say it at the top that VAWA's protections cover all survivors of domestic violence, dating violence, sexual assault, and stalking, regardless of race, regardless of sex, gender identity, or sexual orientation. So just because the title of the law has women in it doesn't mean it's protections limited to women. So what I want you to know about VAWA's housing protections is that they're very strong protections, which is great, but they only apply in federally subsidized housing. Okay, so first and foremost, when we're doing our advocacy in this space, we're always trying to figure out what type of housing is this? Is this federally funded? And if it's federally funded, then it falls under VAWA, and we know we have VAWA to use and all the tools under VAWA. It does not apply to state-funded subsidized housing, and it does not apply to private market housing in Massachusetts, unfortunately. So when we're talking about these protections, think about federal public housing, think about your Section 8 vouchers, think about project-based Section 8, and think about tax credit, low-income housing tax credit, and pretty much any other type of federally funded housing. Any program you can think of, if the money comes from HUD, VAWA applies. One caveat that we're going to talk about a little later is that actually, wonderfully, the MRVP program, which is the Massachusetts Housing Voucher Program, has adopted VAWA. So even though technically it doesn't, this is federal law that only applies to federal housing, MRVP has said, we want VAWA to apply to our program. And so if your participant has an MRVP voucher, VAWA also is in play, okay, for you to be able to try to protect their housing. So the most recent reauthorization of VAWA has expanded the definition of domestic violence to encompass, similar to the state law, right? The state 209A definitions of domestic violence now encompass concepts of coercive control. VAWA does as well, and you may have already encountered this in your work under VAWA, but it's maybe worth saying it has occurred in the housing context as well. So this is no longer just limited to felony or misdemeanor crimes of violence, but has been extended to a pattern of coercive control, which is quite a broad, quite a broad definition of coercive control. VAWA also applies to dating violence situations. So if you don't have to have a child in common, you don't have to be married or have been married for VAWA to apply to the housing. A dating relationship is enough. The stalking definition under VAWA is one that I like to linger on a little bit because it is very broad and it covers a lot of different kinds of situations that you might not otherwise think it would apply to. So stalking is defined as engaging in a course of conduct, which is really important. It has to be a pattern directed at a specific person that would cause a reasonable person, so it's a reasonable standard, to either fear for their safety or the safety of others or suffer substantial emotional distress. So please notice that there's no relationship requirement here, right? This could be a coworker, this could be a neighbor, this could be a random person you don't even know who they are. We just had a case like that where there was stalking by a stranger. This could involve youth violence. I've had a case where a client's child was being targeted repeatedly by another youth, and we were able to get that family relocated using VAWA. So it's a very broad definition, and you might get housing providers saying, wait, this is not stalking because this is not domestic violence, or this is not, they don't necessarily recognize it. So sometimes we have to do some work to bring them along. So economic abuse is now part of covered under VAWA, and then sexual assault is still the same definition, which kind of just refers back to the local jurisdiction's definition. And that has always been the case. Okay, so if a survivor that you're working with has experienced any of those types of abuse, that could qualify them for housing protection. Okay, so then what does the protection say? So what it says is an applicant or a tenant in covered housing may not be denied admission, denied assistance, or terminated or evicted because of their experience of gender-based violence. Okay, so if we can connect the reason on the notice to quit to the experience of abuse, we have a defense under VAWA to the eviction case, no matter what it is. Okay, so this really is potentially really powerful because, as we know, the experience of abuse for many of our clients permeates all aspects of their life. It's not just isolated to one arena in their life, right? It impacts finances. It impacts how loud their family is compared to other, whether their family is, whether there's noise coming from their apartment, right? All kinds of things that could implicate lease violations could be traced back to that family's experience of abuse. So that's the work, is trying to kind of understand from the client, how do we get to the place where these allegations, well, first of all, do we agree with these allegations? Do we think they're accurate? And then what kind of context can we bring to help people understand that these allegations in the notice to quit, this reason for the eviction, is actually a result of our experience of abuse. And that's how you could potentially win an eviction, or a survivor could win an eviction. So an incident of domestic violence, or gender-based violence, I should say, cannot be considered a serious or repeated lease violation for purposes of terminating a voucher, terminating a lease, and the covered housing provider can't refuse or deny or evict someone based on criminal activity that's a direct result of gender-based violence. So these are potentially also very powerful aspects of the defense that we can bring to bear to protect the housing of our clients. The other thing to note is that there is, at this time at least, a regulation on the books that says that housing providers are supposed to do whatever they can to keep survivors in their homes. And it's not as strong as it could be. It doesn't say covered housing providers must or shall. It says are encouraged to do whatever they can. But it definitely is an articulation of the expectation, right? HUD is the funder, HUD is the regulator. HUD has an expectation and is encouraging housing providers to try to find ways to keep survivors housed, not look for ways to evict them, right? And so if you can remind them of this responsibility, sometimes that can help them be more collaborative in the process. So a couple more things before I pass it to Vineeth under VAWA that are really important to know. A housing provider cannot discriminate against anyone who has participated in either requesting VAWA rights or helping someone assert their VAWA rights. And this is a new protection under VAWA. There can't be retaliation against anybody who calls law enforcement or emergency assistance on behalf of themselves or someone else in need of assistance related to gender-based violence. So nobody should be getting an eviction notice because the police or ambulance had to come to their house to respond to an incident of abuse. And unfortunately, that happens all too often. So this is an important new dimension of the VAWA protection. There are some housing protections within VAWA that are very helpful for survivors who are trying to keep their homes or potentially relocate. One of them is called bifurcation, where if you have co-heads of household and one person has been causing harm against another, and then that person causes the housing provider to bring an eviction action, bifurcation can actually allow the housing authority to remove the harm doer and allow the survivor to stay in place in the apartment and to keep the lease. So that can be kind of powerful in some circumstances, although it can be kind of difficult too, because it's a confrontational kind of remedy where you're actively working with the housing authority to remove someone in a way that could implicate, I think, safety issues. There is such a thing as an emergency transfer. That's where a survivor asks the housing provider to move them to another similarly subsidized unit to get away from an unsafe location. And that can be potentially beneficial, although there are some challenges there, which many folks have maybe encountered and which we can maybe talk about more in the question and answer part of the presentation. But one thing to know is that if your participant or the person you're working with has a voucher, they're allowed to break their lease with their private landlord without breaking the Section 8 rules in order to move for safety reasons. So usually the Section 8 rules require you to live in your apartment for at least a year before you leave. And if you leave before that year is up, you could be jeopardizing your voucher. But there's kind of a safe haven provision that allows survivors to leave before that year is up if they need to for safety reasons. Okay, so last couple things on VAWA. Landlords are allowed to ask for proof that the person qualifies for VAWA, but they're not allowed to require any one type of documentation or any specific type of verification. VAWA has kind of a menu of options that survivors are allowed to choose from and are encouraged to choose the safest method of documentation that they determine to be the safest. So that could be a self-certification form, that could be a police report or a restraining order, or it could be a letter from a qualified third party like any of you. But just note that the tenant, the provider does have to sign that under the pains and penalties of perjury and has to say that they believe that the survivor qualifies for VAWA protection. So it's not just any letter, it's kind of specific in what that letter has to say, but it's sometimes the best way to document VAWA eligibility. So, so please know that it is an option and that it's so helpful when we know the survivors can have a trusted advocate to help them with that. Okay, so I think that's it for my part. I will continue doing the slides, so I'll try and keep time with you, Vineeth, but I'm happy to pass it over to you.
Great. Thank you so much, Julia. So Julia just went over federal housing, federal subsidized housing, and VAWA. So I'm going to quickly go over the protections available to survivors on the state level. And so the first category is state public housing protections, and specifically within that, looking at applicants to state public housing. And I think what you'll see with from what Julia has presented too is that some of these principles and concepts it does overlap between how the federal law is laid out and what we see on the state level. So for example, with applicants to state public housing, there is a regulation that says that applicants cannot have the least violations caused by acts of domestic violence used against them in the application process, that those are considered to be mitigating circumstances. So again, like we kind of saw on the VAWA side, the actions of the abuser, those cannot be pinned on the victim and use that and used, as a justification to evict them from housing or to recede their rights in any way. Also, survivors of domestic violence are also given a certain priority status, priority 4, on wait lists for state public housing. Additionally, kind of what Julie just talked about with the VAWA and how housing providers are encouraged to protect the rights of survivors. We see also on the state side that housing providers are encouraged, or actually they must provide reasonable and appropriate assistance to tenants who are victims of domestic violence. And so this could include granting a transfer, and also rekeying locks for folks that need their locks rekeyed for safety. And additionally, if a survivor of domestic violence is documented to be so, and they remove the abuser from the unit, the housing provider cannot evict the remaining tenants for the damage, disturbances, or other lease violations caused by the abuser. And then moving out of the state public housing category and looking at just state housing protections kind of in general, we do have some pretty strong state protections for survivors. Survivors cannot be evicted for calling the police or for accessing the court system for their safety and to assert their rights. They can also break their lease for safety reasons, and we'll go into that in a little bit. And also, they do have protections on the state level for changing their locks for their safety. And then kind of what we also saw on the VAWA side. So protected tenant activities include being able to report to police officer, access the court system, find safety, and the landlord cannot retaliate against survivors for doing any of those actions. And if an eviction is brought within 6 months of any of those protected activities, then it is presumed to be retaliatory. So that's really important. And what I just talked about with survivors in Massachusetts having the opportunity to break their lease for safety reasons, this is something that I think, at least in our practice, we see a lot of folks that are survivors that have experienced domestic violence. They are often in a position where they need to leave their home and they need to seek safety. And that can be done in Massachusetts if that survivor does two things. The first is to provide written notice to their landlord, and the second is to vacate the unit. When those two things happen, that date is called the quitting date, and they are no longer liable for their lease after that quitting date. So, for example, a survivor provides written notice to their landlord today, September 15th, that they are vacating their unit because of domestic violence and that they're seeking their safety, and they vacate their unit tomorrow on the 16th, the 16th would be their quitting date. So they are not liable for the rest of the month on their lease or even the rest of their lease. And so they're provided or they're liable for their prorated amount for the month, but nothing after. And also, if they prepaid a month or if they paid last month's rent, they are, they should be getting that money back as well. And that is some advocacy that we do in our office. It's not something that landlords, I think, are necessarily very aware of, or they maybe are just kind of waiting for survivors to actually assert those rights. But that is something that is really an important tool to get folks out of unsafe situations and to find safety. And then to just kind of go into this a little bit further, that incident of domestic violence must have occurred in the past 3 months, or there must be an imminent serious physical harm or fear, sorry, of physical harm from domestic abuse for someone to be able to assert that right for a lease termination. And then this also, in terms of what kind of proof a landlord may ask you for when you're asking for a lease termination, this also kind of follows what we see on the VAWA side, in that you can provide a copy of a harassment order or an abuse prevention order, and also a court record of law enforcement. But then what we also see is a written verification from third parties, so domestic violence organizations. And I think, at least in my experience, a lot of my clients, that's kind of their preferred method. They kind of feel like they have a good relationship usually with the domestic violence organization that they're working with, and that's kind of the way for them to maintain some type of privacy, and not like exactly turning over court records or anything else that they may feel uncomfortable with or sensitive to. And that, I think, has been a good tool for them to be able to provide verification of the domestic violence that they have suffered from. And then also there is a state right as well for a lock change for safety. The landlord must change the locks within 2 business days, and if not, then the tenant can change the lock on their own. Okay, so went through that really quickly, and I think we still have some time left for questions, and I saw some questions in the chat. So
all right, so I just first want to say thank you all for bearing with us. That was like a lot of speed talking, but the big, hopefully good news is that you're going to have these slides. You can refer back to them. We did try to be kind of overly comprehensive so that you could use them as a reference. And I just, before we jump into questions, wanted to say, to try to put this training into context for like the learning goals we have in general for this training series, is to understand, like, again, the foundational information that you need to know about evictions in Massachusetts, how we can advocate and push back for our clients who are survivors within that process. But then if we meet someone who has evictions on their record from the past, or it's something that we weren't able to stop for whatever reason, what can we do to help them move on from that through eviction sealing? So then eviction sealing comes in as the next chapter of this training. And then hopefully we can all go out and help people make sure that these experiences of eviction are not holding them back from future housing, healing, and self-determination. So I'm going to stop sharing slides, and I think, Greta, if you want to help us
Yeah, of
answer
course.
the question.
Thank you both so much. I think, thank you for the VAWA and state law refreshers. I think those are always helpful. And I know I see some of the questions you answered in the course of the presentation, which is awesome. So I think the first one maybe is, do tenants pay for the constable fee? So the different fees associated with going back, are tenants paying for those?
So the landlord has to pay for constable fees when they hire the constable. I think one of the early slides says that the notice to quit does not have to be served by a constable, but the landlord's going to have to prove that the tenant received that piece of paper down the line in the court case. So often they will have it served by a third party who can come to court and testify that they provided that document. The tenant cannot be charged for that fee, but because it's not required. But the filing fee and the fee for serving the summons and complaint can be part of the judgment that the tenant has to pay, and often will be part of the judgment. So if there is a judgment against the tenant, so it's not rent. It shouldn't be on someone's ledger necessarily, but it is something that the landlord legitimately can claim from the tenant once that case has been filed, unfortunately.
Super helpful. And actually, Maggie, who asked that question, I see your hand is up. Do you have something to add to that question before we go on?
Yeah, well, I was the one who asked about the constable fee because one of my clients is having a $50 fee on that. And also late fees and improper trash disposals. So is she's not supposed to pay for the constable fee, right?
So it depends on what the fee was for. If it was for service of the summons and complaint, it could be something that the landlord is justified in charging back to her. But if it's a different notice, I can't think of one other than the summons and complaint that the landlord would be allowed to ask her to pay.
I see.
And then the other things like late fees and trash fees, if those are allowed in the lease that this person signed, they might be allowed to charge them, but they are not rent. So a landlord can't bring that tenant to court for non-payment of rent and include those fees.
Oh, okay.
It would have
Alright.
monthly rent that person has not paid, and that's all that should be in the notice to quit, and that's all that should be in the summons and complaint, and that's all that should be an issue in the eviction case. The landlord could do a case for failure to pay those fees, but it would have to not be a non-payment case. It would have to be, you broke the lease by failing to pay fees that you agreed to pay.
Okay, thank you.
Okay, hope that's helpful.
Thank you so much. Before I ask the next question, I will say that I will also send out referral information for if you want to get in touch with these lovely folks. And so I know it flashed on your screen, so maybe you quickly took a screenshot, but I will send that out. And then we had some questions about documentation, which I think you answered. But we also had the question, what are the most common defenses survivors can use to delay or stop eviction? So I think we talked a little bit about that, but if there's a way to kind of refresh on, I guess what you're seeing, because I know this is new, so maybe what you're seeing too from the field about what is working and what is still kind of like questions out there in court.
Well, it really does depend, I think, on the type of housing we're talking about. So unfortunately, like our ability to protect survivor housing in federally funded housing is we have more tools in the toolkit right now. That doesn't mean that we can't do it in other types of housing, but it does make it a little bit more of an uphill battle. Because right now in state law in Massachusetts, we don't yet have a protection from eviction for the status of being a survivor, right? Which we need. But we don't have that. So what we have under state law is a protection for survivors who call the police or who get a restraining order. But I don't need to tell this group that that excludes many, many people who need this housing protection, and the state law is just not applicable to them. So it's really not enough. If you're in federal housing, you have a much stronger ability to say, look, the reason you're evicting me is because of abuse, and I'm going to explain to you that connection, because sometimes the connection is not easy for landlords to, often the connection is not easy for landlords to understand. So the survivor does, or the advocate does, have to help connect those dots and explain how one thing leads to the other. But if you do that, the court should not allow that eviction to go forward. That would be an illegal eviction, would violate VAWA. But you know, and then again, as Vineeth said, there's a brand of an eviction defense in state public housing, but it requires that the survivor take action to remove the abuser, and only after they've removed the abuser would they be eligible for the defense. So there's a few more hoops to jump through there. But you know, creative, relentless advocacy is required here, but we can almost always find a way to explain why the housing is so critical, and also why whatever is destabilizing the housing can be traced back to gender-based violence if that's the experience of our clients.
That's super helpful. And I was going to make explicit what I was picking up, but you did it anyway, which is that I think this is not the end for what is needed here in Massachusetts. And so I think JDI would like to keep, you know, hearing stories about what's going on. And I think Julia and your team, you would like to also. So because there's potentially future advocacy that we could get together on. Thank you for dropping your referral information. Okay, I know we're a little over. If you both have a minute more, Maggie, you raised your hand. Would you like to ask your question?
Yes, very good.
Oh yeah, it's me, Nancy. I have a
Hi,
question.
Nancy.
Hi. So basically, I want to ask if there are cases where eviction can be blocked because of retaliation or discrimination.
Yes, so in Massachusetts, discrimination in housing is unlawful. So there are a number of protected groups under the discrimination law, and family status, race, gender, sexual orientation, ethnicity, national origin. There are a number of different disability. There's a number of different protected categories, and an eviction or kind of like adverse action by the landlord taken against a tenant based on their membership in one of those groups would be illegal, would be discriminatory, and under Massachusetts law would not be allowed. And that's a more comprehensive law than the federal law. So that's an example where the state of Massachusetts has gone beyond what the federal law has on the books. So that protects people no matter what their housing is, and that's available as a defense to eviction. And you asked about retaliation. So retaliation is a defense to eviction if a tenant has engaged in a specific type of protected activity, and then the landlord brings an eviction against them because they did that protected activity. And protected activities under Massachusetts law include organizing in a tenant union, requesting repairs or improvements that are needed to bring the apartment up to state sanitary code, reporting bad conditions to public agencies, suing the landlord, or calling the police or getting a restraining order for protection in a domestic violence situation. So if a tenant has done any of those are considered protected activities that the landlord cannot retaliate against. And if you can show that it's retaliation, then that eviction is preventable.
Thank you. And I just want to ask our interpreters, I know we're over. How are you doing? Do you have another minute or two? No, not really. Okay. I think with this, I would like to just thank everybody for being here today. I'm going to send out an email again, and we're going to have another session on the 29th. We are asking that folks watch this introductory session first, so I will send that out, and I will share Julia and Vineeth's information to the referral line information. And I really am grateful to you both for being here, grateful to all of you for your questions, grateful to our interpreters, and we will see you again very soon.
Thank you.
Thank you for having us.
Thank you.